Everyone.
This meeting is being recorded.
Welcome to our remote online notarization discussion. We'll also have some in-person notarization conversation as well regarding the new laws here in New York. I appreciate you're all coming, and I certainly appreciate this panel of experts who graciously agreed to come on and talk to us a little bit. A few housekeeping tips. We'll leave the chat open. You're certainly welcome to converse or share information amongst yourselves. If you have any questions, I ask that you put them in the Q&A. We'll try to get to as many as possible at the end of the conversation. Whatever we don't get to, we'll be sure to forward out that information afterward for your review. So I would like to go ahead and introduce our panel. We have Christopher Holtzman. He is the VP of Corporate Underwriting, First American Title. Brian Webster, the president of Notary CAM. Tim Reininger, he is the digital counsel for eNotaryLog, and Bill Anderson, VP of Government Affairs from the National Notary Association. If you don't know me, I am Marcy Tiberio. I am the president of Professional Notary Services and the founder of the New York Notary Alliance. So welcome all again. We're going to get right to it because I know we have a lot of material to cover. So Tim, can you start us off and let us know what exactly is RON? How does that differ from IPEN or in-person electronic notarization and traditional notarization?
Sure. Thank you, Marcy, and for inviting me to this panel, and thank you for everyone for being here. So remote online notarization, as it's generally called, is simply, from a legal perspective, the use of communication technology to invoke the legal authority of a notary as a public officer. And so up to this point, traditionally, that authority could only be invoked in a physical presence. And in past times, there were some who had hoped maybe a use of a telephone would be enough and all that, and that was clearly rejected by legal authorities and others over the years as being totally unreliable. But now the use of audio video component, which is two-way live, is has been deemed by nearly all the states at this point as sufficient to invoke the authority of the notary as a public officer. Now, just to also a quick question, there's confusion about this as to, is this only for electronic documents? Only can it be for paper documents? And the Virginia approach, the first approach, contemplated that, if you're going to use audio, video, and technology, it's going to be, you're going to want to use electronic documents and records and signatures. But starting with Montana, there are some use cases coming up, and people still wanted as their, let's think about it as your product, or whatever your legal situation, if the product needs to be, usually because of the relying parties, still has to be a paper document. The RON can accommodate that. There's a lot of flexibility to suit the various legal needs of your clients, your situation. And I'm sure Chris will touch on it later. The land title has made great efforts, had great success with allowing even you can paper out an electronically signed document, and that will be able to be recorded. So you have lots of flexibility. By the way, IPEN is the in-person use of a signing of electronic record document. That is classically, the signer still in person in the same room with a notary in front of a computer performing the notarial act. That went back to what the signed UETA laws, 1999, 2000, and the New York version of it. And it had relatively little traction over the years, but there are still use cases for it. And as you'll learn, the New York law also authorizes that. So you all in New York have great flexibility. You have a lot of ways to strategically leverage this law. Thank you.
Wonderful. Thank you. And what is the legal precedent behind allowing a notary in one state to notarize a document for an individual in another?
So all of the state enactments of the RUM laws expressly authorize that the signer can be anywhere physically outside the United States, with some requirements put into that. That's a special case. You can have your client on a business trip in Germany or England, and you can still perform with your New York notary a RON. So that has been allowed. We probably will touch on. This has been controversial from the beginning. That it was very hard for people back 2011 to conceptualize the idea of, when the legal system is so wedded to physical presence, physical jurisdiction, and all of a sudden now the signer could be anywhere. But the whole legal system has struggled with cyberspace in general. Jurisdiction of the courts, tax matters, this and that, and so we have, as in the notary world, also joined this fray in a very interesting way. And I've been seeing less and less questioning about that. We'll get to some of the issues around where is notary physically, and the New York law expressly requires the notary to be physically in New York.
Great, thank you. So Bill, tell us a little bit about what the requirements are to become an e-notary in New York.
Thank you, Marcy, for inviting me to be with you today. Greetings from the West Coast, in Los Angeles. According to the statute in Executive Law 135C and the new regulations that were just published last week, you must be a commissioned notary to register to become an electronic notary. And you have to go through a registration process where you apply to become an e-notary. This is not a separate commission, it's registration. And there's a $60 registration fee that you must pay. And in your registration, you're required to describe the electronic technology or technologies that you're going to be using to perform electronic notarizations. You must also provide a sample of your electronic signature using your selected signature vendor that you describe in the registration. The signature that you use must include your name and any instructions, authorizations, or techniques that allow the electronic signature to be read and verified. For example, if you use a digital certificate, Next 509 digital certificate to sign your name as a notary, you would have to provide the public key of your private public key pair of the digital certificate so that the Department of State can read it. And then finally, upon reappointment of your notary commission, when you reapply and you want to continue to be an e-notary, you must provide verification of the accuracy of all information on file with the Secretary of State. And then you must also confirm or affirm that you are in compliance with Part 182 of the regulations.
Now, Bill and we talked a little bit about this before jumping on here, but this e-commission is not just for remote online notarization, is that correct?
Yes, Marcy, it's a good question. From the regulations, if you read the regulations and the statute, it sounds like it's talking only about remote notarization. And the word electronic notarization in the regulation is essentially defined as a remote notarization. But the Department of State has informed me that if you only want to perform in-person electronic notarizations and not remote notarizations, or if you want to perform both an IPIN and a RON, you must register to become an e-notary.
And that was not the case previous to now, so that's an important piece as well. I know that there's been some conversation about what happens to your original commission. Are there two separate commissions? We actually confirmed this morning that once you receive that e-commission, that is your commission number, your renewal. your traditional commission number goes away. So you'll want to make sure that moving forward, you use that e-commission number that was given to you for your stamp, both for in-person electronic, Ron, and in-person traditional. If at any time you decide at the end of your commission you don't want to renew that electronic commission, you would need to apply for traditional. I know it's been a little confusing, so I appreciate the information we got from the Division of License this morning, and thank you, Bill, for clarifying that information. Tim, talk to me a little bit about the platform requirements for Ron and a little bit about the VPN that seems to be an issue, the location piece for notaries.
Sure. And since I'm not a technologist, I'm certainly hope that Brian jumps in if he's free to. But the platform providers bear a lot of responsibility here, and so if number one, any notary, I don't care if you're at a big law firm day or something, you're going to want to get a good third-party run vendor to work with. You're not going to want to have your IT people just build it in-house or something like that. And there are certainly a few matters of the requirements. Things to credential providers will provide the secure two-way live capability, audio, video signing process. You'll have issues of maybe multiple signers that come up, and I think all the top providers accommodate multiple signers. I know that your corporate settings, you're going to have a lot of situations of multiple signers and complex signers multiple places. So Notary Cam and others will accommodate that, but you'll have those issues around with the signing, document management, and the audio video capabilities, but now also the credential service provider aspect. And I think when Ron started, and in many states, there are third-party providers out there. They could be LexisNexis with knowledge-based questioning. We'll get into some of these things. There are entities, Jumio or others that do credential analysis, get into that. But in terms of what I see, especially with New York here, referencing, I think for the first time in a state law, a credential service provider, and New York is tracking where the federal government is going with these things. I would say the platform providers are going to be, a good one is going to be also providing that service or have that capability. And the liability issues, so forth, to go around that. So then finally, Bill Anderson alluded to this. You always have to have the ability to authenticate the notary. So legally down the road, and this gets missed a lot of states and others, this basic evidentiary issue here. The notary is put in this key position, but you can't have a law that doesn't have security and requirements around what the notary is doing with the sealed signature. New York does that. So you have a great law around these issues. And Bill alluded to the terms of art there, the digital certificate of PKI. So the RON vendor needs to be able to also accommodate that.
Thank you. And then I'm going to go right to Brian, because that VPN issue sort of relates to our next question is, where is everyone in this transaction? Where can the notary be? Where can the signer be? How does that, affect this VPN, or why is the conversation so important around a VPN? Why does it matter?
Yeah, thanks, Marcy. And Tim kind of alluded to this a few moments ago, and as it relates to kind of physical location, that's the beauty of the remote online notarization and the technology, right? So the signer has far more flexibility in where they can be physically located compared to the notary. Tim even used examples of, someone on a business trip in Germany, right? They can be almost anywhere in the world, outside of the United States. We have a client where all of their customers are international signers. It's not in real estate, but that's their business model, right? And so we're able to accommodate that through our platform. The notary doesn't have nearly as much flexibility. right? So the notary is required to be physically located and conduct their duties within the state in which the notary is commissioned. So like within the pandemic, we had a few of our notaries, they're like, I'm going to go to Florida for a month on vacation. Can I continue to, notarize documents? And we're like, sorry, you can't, right? Because of those restrictions that are on the notary. And that makes total sense, right? The Secretary of State and the states, issue these commissions and control the actions and duties of the notary. And all of that pertains to laws dictated by the state. Tim, you mentioned, typically it's been defined by physical location and boundaries. And so, that's really kind of what dictates what the notary is able to do and where they're able to do that.
So just to clarify the VPN, the issue with that is that it hides or changes the location of the notary, correct? Am I understanding this correctly? So it's not evidently apparent that I'm in New York doing Iran. If I were to use a VPN, it could show me in Texas or Ohio. Is that, am I correct in saying that?
Yes.
And I'm not the technology person, so I throw that out there.
It could, right? And part of the responsibility of the vendor is tracking, the IP addresses and the locations of all of the parties, right? And so, if a notary or signer is using a VPN, they can mask kind of where they're located. That goes back and falls on the responsibilities of the notary in order to, they're commissioned in the state, they are licensed, and, they have the requirements and duties in order to follow the laws in which they've received their commission. And one of those is to be physically located in the state. And so that is, part of their, ethical duty in order to be able to, reside within the state in which they're commissioned.
Great, thank you for that information. So Chris, tell me a little bit about the fee per notarization. What can notaries charge?
Sure. For a traditional paper in-person notarization, I don't believe the fees changed with updated regulations in the statute, but for an electronic notarial act, the notary is able to charge $25 per electronic notarial act is what the updated regulations say.
And the regulation, if I'm correct, says it's an all-inclusive fee. So the notary can't charge additionally for storage of the recording or didn't
I
saying
believe
that
that's correct. It says
$25.
all-inclusive fee, yes.
Perfect.
Yes.
So Tim, tell me, how will someone know if a document was notarized by Ron? Do we need anything additionally added to the document, verbiage? How will they know? What do we need to do as notaries?
Yeah, it'll be very easy. All of the states now, including New York, require that the notarial certificate include language to that effect. That in some of the states prescribe exactly the language, but it has to be in so many words that this notarial act was performed, the personal appearance was fulfilled by use of communications technology, by means of communications technology. This has been an issue over the years. The original law in Virginia did not require that because the view was that, frankly, not to cast as radical, but it kind of was a natural evolution of the notary office and so forth, but became controversial and quickly friends in the land title industry and banking wanted to know if something had been notarized with the use of online notarization. So at any rate, now that's been cleared and it's very easy to know. In fact, I think it's going to go the other way, that there's so much more security and reliability around the RON process that I think relying parties are going to want to see that process is used.
Thank you. So Brian, just some general housekeeping is, if the signer is in one place and the notary is in the other, what is the venue for our notarial act?
Yeah, so that gets a little, I don't want to say tricky, but comes into play in the conversations quite a bit, right? As Tim kind of alluded to, there really isn't a venue for these type of transactions, right? It's all done virtually. Tim mentioned that each state, or majority or all the states now require that statement gets applied to the documents, that it was conducted remotely via audio video communication technology. And so since it's being done that way, it's a virtual setting, so there's no physical venue. But the reason why you want to look at the venue, is what are the applicable laws that govern the transaction? And Tim, Bill, Chris, you guys are legal experts, so please correct me if I misspeak here, but it's really kind of pertaining to kind of the laws that dictate the transaction, right? And so first and foremost is going to be the state in which the notary is commissioned, right? Those are going to dictate the requirements of the notary and the duties of the notary. It can also depend upon the state in which the documents are being recorded, even down to the county level, right? So like with First American and Chris, for real estate transactions, that's going to depend on the property state in which it's located. So there's going to be laws govern the transfer of real property and the recording and making public these type of documents pertaining to real estate transactions divided by the state and county. So when you're looking at kind of from a raw transaction, you have to look at a few different areas to ensure that you are taking into account all the applicable laws and regulations that kind of define that transaction. For us as a vendor, we have our legal counsel that advises us on that, but especially on real estate transactions, we lean very heavily on our title underwriter partners, right? And so if Chris at First American says we'll insure the transaction, that gives us the confidence that they are insuring the transaction and feel like that what we're doing and what our notaries are doing are adhering to the laws applicable to this specific transaction, and vice versa. If they want to insure it, then we need to make sure that we make the necessary adjustments or changes in order to make sure that this is an insurable transaction. But this gets back to kind of, I think, a very, very valid question and a similar question that comes up quite often, especially as we talk about technology and innovation. Whether it applies to RON or e-closings or an e-signing or even buying a car online. Human nature is to apply existing paradigm that's been around for decades to anything that comes along, right? Like, it's new, I'm going to hit it with a stick until I understand it. It's human nature, and like I said, completely understandable. And I've been guilty of doing things like that. But as an industry, and if we can get over that hurdle, to look at these new capabilities independently and understand how we can take them and apply them to our various business models, we'll begin to see that accelerated adoption, of innovation that other industries have experienced, and really real estate and especially, mortgage and title have really been left out of.
Thank you. And how about the date? If I'm in one time zone and my signer is in the other, what date do we reflect on our documents?
For us, it's the date, the time where the signer is located. That's what we capture within our system. So like I said, with our international transactions, it's going to be based on where the signer is located. And even within state, you can have variations within the time zones. And we always capture that based on, like I said, the location of the signer and the execution of those documents.
I'm going to throw that out to anyone else if they want to add something to that, or.
Well, if the notary, we're going to talk later about record keeping, and the journal requirement that we will talk later about requires the notary to record the date and approximate time of the notarial act, and that would, I take it, would be the time to the notary. So while the system may record the signer's date, the notary would want to record the date where they are located.
So to be clear on that, Bill, absolutely correct. So within our platform, we do capture both, right? And so within the audit log and what we're looking at is not just the signer's date, time, and location, but within the notary journal, we do that. We capture that specific time and date from the notary's perspective as well.
Yeah. Great, thank you for that information.
Yeah, no, Marcy, if I could jump in, I think
Sure.
I just remember from the small amount of time I spent in a corporate practice, the great stress in the law firm when there was a big closing of a deal and the timing of signatures, and it'd be very stressful. So I'm curious from Chris's perspective, closings of real estate, when I've mentioned many times with the dates, the closing has to be done by a certain date and all that stuff. How do you all approach this issue of the signers being in maybe a different day, their time zone, the notary?
It's a great question. I too have experienced that the stresses of getting a closing done and wire deadlines, cutoffs, moving money, etc. I think one of the things that I always emphasize to my people in these scenarios, especially because in the grand scheme of things, Ron is so much, I don't want to say in its infancy, because I think it's certainly been accelerated and we're getting close to that point where eventually it'll scale much longer, reach that tipping point. But one of the big things I tell all my people is we need a little bit of time, because I think the process, it's not just us as industry experts and people who live and breathe this every day. It's how do we convey that to our customers, manage their expectations, and make sure that they're going to have a good customer experience. The same way I want the customers and these signers to have a good experience while being safe and secure. I know, Brian does, everybody does. We all want that. That's in everybody's interest to have a good signing experience. So a lot of times when we have the more complex scenarios, it's about, we need a little bit of lead time, making sure we're educating our customer with some of the process, some of the things that have come up, things that, having lived and breathed this every day for the past few years, I wouldn't necessarily think about, where you're working on a closing, and this usually isn't a complex transaction, but more so it's an accommodation. Somebody's traveling overseas and they won't be back in time to do a closing. A lot of it's about managing the expectations. Do you have the right internet speed? I mean, simple things like that. You got to make sure you have a camera or a computer with a webcam. Things like that. That's, I guess they kind of fly over my head sometimes because you're so in the weeds, are really important to manage your customers' expectations, whether that's a big corporate client and it's complex transaction, or just a residential refinance transaction, whatever you're dealing with. I think that's key. And I do think we will get to the day where this just becomes a normal habit. And it's, okay, this is a Ron transaction. We need less lead time, because not only do we as a title company, the Ron vendors, but also our customers understand the process. They know what they need to do. And I think that'll go a long way in accelerating Ron in general.
Thank you, everyone, so much for that information. I'm going to switch gears a little bit, because within this remote online notarization regulation situation, there are some traditional notarization changes that have been made that I think are very important. So I'm going to throw this over to Bill. Tell me a little bit about the new identification requirements, because previously in New York, we didn't have any standards, and now we do.
Yes, this was interesting when the regulations were published. At least I was expecting remote-only regulations, but there were several provisions that were also added to the rules that apply to all traditional notarizations. One of them happens to deal with identification. Previously, I believe the real property law was really the only statute that said that the notary must, in taking an acknowledgement, must be has satisfactory evidence of the identity of the signer, and that's where it stopped. There were no other rules. But with the new regulations in Part 182, they expressly state, in general, 3 ways you can identify someone: with identification documents, by the notary's personal knowledge of the signer and through witnesses. So let me go through those a little bit with more detail. With regard to ID documents, there's two options, okay? The first and the best, frankly, is that the signer must present front and back one government-issued ID by a government agency that meets four requirements. Number one, it's current and valid. Two, it has the bearer's photograph. Three, it has the bearer's signature. And if applicable, an accurate physical description of the signer. So if the ID has a physical description, it's got to match the signer. So one ID that meets that, okay? But the regulations also say if not, you can have the signer produce at least two identification documents issued by an institution, business, entity, or federal or state government with at least the individual signature. So under that requirement, a Social Security card would meet the requirement because it's got a signature and it's issued by a federal government. Maybe a university ID card with a signature, or even a library card could possibly mean a credit card with a signature, okay? But we would recommend that you always use the first method, one ID front and back of a government issued ID with those four elements. Okay, so that's ID documents. Number two is your personal knowledge of the signer. You've always been able to do that. You'll be able to continue to do that. But thirdly, it also says you can use a witness or witnesses. And so the rule says that you can use one witness who swears or affirms the identity of the signer, who is known both to the notary and to the signer. Now, in today's world, that's probably not going to happen a lot unless you live in a really small town. So the regulation allows the use of two witnesses who swear or affirm the identity of the signer. And in this case, they won't know the notary personally. So the regulation says they have to provide an ID from that first type of ID documents, front and back of an ID issued by a government agency that is current or valid, has the bearer's signature, photograph, and if applicable, accurate physical description.
Now, do we need to identify the witnesses as well? Do we need to verify their ID?
Do you need to verify their
identification for a witness? Do we need to verify they are who they are?
Yes. In the case of two witnesses, you do. They have to actually present that ID front and back of an ID issued by a government agency, because the notary is not going to know them. Okay. But if you use one witness and they're personally known to the notary, then that is sufficient.
Perfect, thank you. So then we'll switch back over to Ron. Ryan, can you talk to us a little bit about the identification requirements when conducting a RON notarization?
Yeah, certainly, right. And so, Bill hit on, two of the ways that a notary can verify the identity is through, personally known to the notary, right? So that's always going to be the case, right? And even within our platform, we allow the notary to, attest to that and acknowledge the fact that they, personally know the signers. But when it comes to an instance where, the notary doesn't know the signer, which is probably 99.9% of the transactions, states will require what they refer to as MFA, or multi-factor authentication. And that is using two separate independent methodologies in order to verify and validate the identity of the signer. The most common forms that you see defined and in use today is through credential analysis and KBA, or knowledge-based authentication. So on the credential analysis, that's typically the first component. The vendor, the platform will ask the signer, the principal, to scan or take a picture of the front and back of their ID. And it requires the exact same kind of criteria for the ID that Bill had kind of referenced for the in-person verification, right? So it has to be an unexpired current, government issued ID, picture, signature, description, all of those requirements have to be met for the use of that ID. The vendor will take the scanned image. It will evaluate the ID for authenticity. It'll look at specific features of the ID to ensure that it is not fraudulent. And, it'll look at things like the edges, does it have an edge? Does it not have an edge? Is there peeling along the edge of the ID? All of those are kind of factors that lead into the evaluation and the results of the credential analysis vendor. We've had conversations where we've gone to the vendor and say, can you share exactly what you look at? And they don't. It's all kind of black box to them. It's very proprietary, kind of that algorithm that they use as a competitive advantage. The last piece that the credential analysis vendor will do is that, they've scanned the back of the ID, which has a barcode, right? If you look at your driver's license, you've got that barcode. That barcode, an MRZ, a machine readable zone, it contains data as well. And the vendors will compare the data from the barcode and compare it to the data on the front of the ID. Legitimate IDs, those should match. And so it'll make that comparison to ensure that what's presented on the front of the ID, it is the same as the data presented within the barcode on the back. The second piece of the multi-factor authentication around the KBAs is these are kind of out of wallet questions, right? That come from, various data sources, but the most common data source used is credit repositories, your credit report data. That's why typically, a signer will need a US-based social security number in order to be able to produce and run the KBA test. A KBA vendor, Tim, you mentioned it earlier, LexisNexis is one that provides a lot of these services. They will generate 5 questions based on that credit data from the signer. The signer will have 2 minutes to go through and answer those questions. And I believe that, a lot of the states define within the regulations that they have to answer 4 out of 5 of the questions correctly within those 2 minutes. They do get a second chance if they fail the first time. But if they're able to pass that, that would be considered, the 2 separate forms of identity verification for the signer.
I want to throw this out here, but I know we didn't talk about it. From anyone's understanding, are biometrics allowed in New York State under the new regulation? Do we know?
In New York?
In New York.
I think to answer that, would they be allowed as an add-on service? For example, if Notary can perform credential analysis and KBA, and then on top of it, also offered a service of biometric comparison, that might be permissible. I don't think it's clear whether that would be a permissible alternative.
Okay, we'll certainly look into that. I'm asking more along the lines of, so that an individual not have a, they're not a US citizen, right? Some states allow for biometrics. That's recently come up, so we'll certainly get more information.
Yeah, some states explicitly mention, some states don't, and it all depends on kind of what the state legislation is. Some require KBA, some don't, some mention biometrics, some don't. It as Chris said, it can be very murky, right? So as as a vendor, as I mentioned before, right, like especially on a real estate transaction, because of the various stakeholders on that transaction, like with the title underwriters, we go back and we coordinate and we lean very heavily on our title underwriting partners, those that are insuring the transactions, to get their kind of legal opinion as far as what is allowed and what's not allowed. What are their requirements as far as identity proofing for this particular transaction and what they're comfortable with. And so that's really kind of how we're approaching it, you know, as a vendor for both the software, but also as providing the RON services as well.
Great, thank you. So Chris,
Marcy,
regarding, oh, I'm sorry, go ahead.
I just want to jump in. You know, this is another great issue. I would say that, you know, New York, it's going to be controversial with some, but I think it's a great opportunity for New York, this idea of the tying to federal standards, which are evolving, but this with reference there to a level 2 and all that. And I know that, you know, at the law firms out there, if you were to take a new lawyer and ask in their first week to go figure this out, you know, can we do biometric? The lawyer will probably quit. You know, it's very tricky, but you're best to interview the, you know, RON providers who are providing, you know, ask if they perform do the credential service provider function. And if you're a law firm or a company and say, look, we have clients in China or Brazil. Do you accommodate this? And some of the RON providers probably will say we don't, you know, or they'll figure it out in some fashion. But you know, you'll leave it to the credential service provider to figure out getting to the L2. You could have a whole seminar on this, by the way, the concepts of federated identity. You know, this goes, you know, this is to me, the most exciting way, the most aspect of RON. You know, now we're getting into this whole world of identity in cyberspace and all the evolving solutions. You know, we didn't have access to any of this in the paper world, of course. And so you know, and they do reference biometrics. Yeah, that's a different story. You know, the other question would be, you know, if your law firm is dealing, let's say, with First American, and First American says we won't underwrite, then you don't do it, you know, or others would, whatever. So you got this interplay of what are our business, what will the relying parties accept, what can the RON provider do, and that will inform, you know, hopefully your RON provider will give you the maximum options for all this. But I just want to use that term of art, federation is big here. And, you know, even the federal government, like the GSA now, is that what they'll say is they'll call it, we need vouching witnesses. You know, it's all a system of, you know, if the federation, someone else has already identity proofed somebody in person and they can vouch for that entity and they can share the attributes and get into all the technical stuff. So I don't want people to come away from this discussion feeling really nervous about this law and how they're going to do it. In fact, it should be the opposite. They should be excited about the numbers of strategic ways they can leverage this for their clients.
Yeah, and I'll just add, I think that's only going to continue to develop in the near term.
Yeah, and you know, this is, you know, I'll probably shouldn't venture down this path, but I will. You know, this is a personal opinion and not an opinion of my employer or anybody like that. But, you know, as Tim is alluding to this, right? You know, innovation is going to continue to evolve as far as like how are we able to identify, you know, a consumer and validate the identity of someone, you know, with the majority of the state legislation that specifies the methods in which, you know, the notary or the participants must be identified, really kind of, you know, hinders our ability to look at new and innovative ways or potentially far more accurate methods of identifying who a consumer is, right? And there's several people within the industry and friends and colleagues that are looking at this challenge to try to come up with, you know, better, more accurate, and more reliable methodologies in order to be able to you know, identify these signers. And so I'm excited about the future of this, right? You know, just like Tim and Chris are, you know, and you know, think that there's a lot of opportunities in the near future for this and for these capabilities.
Great, thank you. So Chris, as we talk about these new ways to identify signers, let's talk about that as it relates to real estate and mortgages. I mean, is that something that we think, oh yes, you can use a witness now, or yes, personal appearance is okay, or we sticking with, hey, you need to use government issued ID?
So it's a great question. Bill went through all the different methods. I'll say on one hand, I think that's a good thing because the reference in the statute of just satisfactory evidence of ID leaves a lot of things, which much of notarial law does, leaves it within the discretion of the notary. I think it's very useful that the state put out a list of different methods to try and, at least get some parameters around it and have some consistency. I think that's a huge positive. Like Bill, my strong preference in every case would be valid current government issued ID. I think title companies are going to look at this individually and make a determination of whether or not they feel comfortable. But I think facts and circumstances matter. If we have, just thinking about how real estate closings go in New York, and you send a title closer in there, and you have, the title closer's done hundreds of closings. There's going to be real estate attorneys who have done hundreds of closings. I don't think that it's going to be, obviously personal knowledge won't be a significant percentage of notarizations that are done, but I think it could happen. And I think a lawyer for their client, it very much could happen where they've worked with them, they feel comfortable, they have that personal knowledge. Now, remember, they have to make an attestation themselves that they do personally know them. So there is a little skin in the game there. It shouldn't just be willy-nilly. Yeah, I personally know them. I met them 5 minutes ago. There do have to be some parameters around that, but I don't want to say it's going to be impossible to happen. The witnesses, I think, will be a little less common. Certainly a witness who actually knows the notary and the signer, it very well could happen, especially in smaller towns, as someone pointed out. But I don't think it's going to be the most common way. Where I could see witnesses coming up is, now remember that government issued ID has to be valid and current. So if your ID just expired, that could be a situation. But what I would say is, if you're presented with these situations, it would be prudent to contact your title company to see whether they're going to be comfortable with that in the end.
Yeah, and let me just kind of piggyback on that, if that's okay, Marcy. To Chris's examples, like with a credible witness, we require the use of a government issued ID, right? And so, driver's license or whatever it is, even for a credible witness. So if for some reason we can't get the signer to pass KBAs or they don't have a social security number, and the title underwriter is authorized the use of a credible witness, they've gone through the evaluation of who the credible witness is and the relationship and kind of done that kind of fact-based determination. We then require the credible witness to go through the exact same identity proofing methodologies as the signer would. So credential analysis with government issue, unexpired ID, KBAs, right? Because, we're relying upon the identity of the credible witness to attest to the identity of the signer. So we need to make sure that, they pass all of the appropriate requirements as well.
Great, thank you for that information. So I'm going to transition over once again to traditional in-person notarization. And now we have journal requirements. Is that correct, Bill? Can you tell us a little bit about the journal requirements here for notaries in New York State?
Yes, this was another surprise when the rules for comment were published and then the rules were finally adopted. Section 182.9 requires records to be kept. And here is basically what the rule says. Number one, that all notaries must keep records. From how I read that, there are no exemptions. So if you're an attorney and a notary, you have to keep records. So as long as you're a notary public and have a commission, you have to keep records. Secondly, you have to keep them for both traditional and electronic notarial acts. Okay, and that's important on the RON side because you also have to keep a recording, but you also must keep a journal on top of that. Now, the regulations don't get into the format of the journal. Does it have to be a paper journal or can it be electronic? Okay, we do know by inference in reading the regulation that records can't be electronic because notaries can have a third-party repository store the record as long as they are password protected. or protected by another secure method of access. And that typically would apply to an electronic record. The rules specify the information that must be included in the journal or the records that a notary keeps: the date, approximate time, and type of notarial act, the name and address of the individuals for whom the notarial act is performed, the number and type of notarial services provided, the type of credential that was used to identify the person, and the verification procedures used for personal appearance. So, if the person appeared in front of you personally, you would basically, you'd point to the ID credential that was provided. Also, with regard to the records, whichever you keep, a paper or an electronic journal, the regulations are clear that you must be able to produce those for the Department of State or for anyone else as necessary. And these records must be kept for at least 10 years. And as I mentioned before, Marcy, you can keep your records in a repository under certain circumstances. And that would specifically apply, I think, to electronic journal records, although there may be repositories as well for paper journals as well.
If I could just add something really quick, Marcy, it's a kind of a personal aside. My mother-in-law has been a New York notary for a long time. She's done a lot of real estate closings. And when she saw the journaling requirement, she, knowing that I've worked in this space, just kind of looked at me frustrated, like, are you serious? And I had to explain to her, and I can understand that because, she's been doing closings for, I don't want to say how long, but a while. And she, she's never had to do this, never been a strict requirement. And what I explained to her was that's to your benefit as a notary. You provide such an important role, and there are a lot of bad people out there trying to find ways to dupe the system. And as something, Tim alluded to earlier, it's a little bit more challenging to dupe somebody using a RON vendor. That's kind of challenging, but some of these fraudsters, the different schemes you see where they're finding an actual document that's been recorded in the public records with the notary seal on it, and then duplicating that, having a journal protects you there. If somebody comes to you and says, did you notarize this deed? We think it's a fraud on this date and time, you can just look at your journal and say, no, you didn't. And that protects you. And I just want to point that because I can understand that it becomes somewhat of a somewhat burdensome, but it's there to protect you ultimately, I would say.
And to add to that, I want to say, it's to protect the consumer, right? The signer as well. It's not just to protect you as the notary. We really want to make sure, especially in New York, where
thank you for that clarification. It goes both ways.
Some higher incidences of deed fraud, right? We hear all about it in the news. We've seen it, that this is an important piece of the puzzle. But Bill, I want to talk a little bit about the actual pieces of the journal because I think there's a little confusion. We are not to log any sort of identifiable information, right? We're not writing down their driver's license numbers or their passport number. We're not keeping a copy of that ID. That is not what we're putting in our journal. Is that correct?
Yeah, that's correct, Marcy. The rule only requires that you indicate the type of credential that you use: driver's license, passport, a green card, or whatever the ID you use, but not any of the PII that might be included on it.
It's super important for everybody to remember that, and you would definitely want to keep your journal secure, correct? Locked. Yes. In a desk drawer or a safe or someplace where not everyone has access to it.
Yeah, and we see that in the regulation where, in the use of repositories. It says you can use a repository as long as your records are password protected. They don't want the repository to get the records and do what they want with those records. These are password protected, so only the notary can get at them, okay? The repository just stores them. It's the notary who's the gatekeeper.
Right. And while it doesn't define an actual journal, I just want to reach out. Are we talking about, can I just use a loose leaf piece of paper? Does it have to be a bound journal, a spiral? Like, is there a best practice for keeping a certain type of journal?
Right, that the regulation doesn't really say, okay, but professional practice would, I think, strongly suggest that if you use a paper journal, it should be bound, and it should be commercially printed with information that is typical for recording journal information. There are a lot of journals on the market that could be used, and they all are bound. And that would be the best practice recommendation for paper journals.
And then I have one last journal question. So the regs look like it says, I just need to confirm how many oaths I gave to that individual or how many acknowledgements I took. Is that correct? Or do we need to list each individual document that we've notarized in that transaction?
Well, it says that you have to indicate the number of services and the number and type of notarial services provided. Okay. Again, professional practice. Think about, Chris was mentioning about the value of the journal. Okay. If this is going to be used in a legal dispute, they're going to want the journal to be very clear and plain. Okay. So we certainly would recommend you keep a separate line in your journal for each notarial act you perform. You complete it in full because people are going to have to read that, and you want to make it plain on its face what information is there so it can be valuable to the parties requesting it.
Great, thank you so much. Chris, I'm going to put you on the spot here. Let's talk about recording documents in the state of New York, right? This is going to be an interesting thing for notaries and county clerks. What do we know? What do we need to know?
So we're in a good place is what I'll start with. The way the statute's drafted, it's going to be very helpful. It's going to prevent some of the log jams that could come up. So we're in a good place is the key here. So I'll start to record these documents. Let's just keep in mind the basic premise. We always need to be recording original documents. So how do we have e-recording? It's because by statute, the statute says you can scan in a paper wet signed document and submit that for recording. Now, not everybody in the world can e-record. It's usually a few people. And how do the counties protect themselves? How do we protect the integrity of the public records? We have that person do a certification that they're in physical possession of the original documents. But how does that work in the electronic world? Well, in the electronic world, a document executed and notarized via RON would be an original in electronic format. So our first preference would be to e-record the document. And this comes up all the time. Well, after the document's been fully executed, I pulled it from NotaryCam's platform. Do I print it out and then scan it to go submit it for e-recording? Because that's what I do in the paper world. And the answer is no. You wouldn't need to convert that to paper. That's one of the benefits of RON, of electronic documents generally. You're cutting out and reducing paper. So your first answer would be go to e-record that document. Now, not every county has e-recording. So what do you do if you're in a jurisdiction without e-recording? Does that mean you can't do RON? The answer is no. Luckily, New York, the legislature fully recognized some of the practical limitations that are on the ground, where not every county has e-recording. And so they created this concept of papering out. And papering out is really just, again, it's a statutory process, the same way e-recording is authorized by statute. Papering out is authorized by statute. And in New York, it allows the notary public, first, they're going to look at that electronic document, verify that no security features on the document indicate that it's been altered since it was signed and notarized. And then you're going to print that out, print out that electronic document into paper form, and then attach a certificate where you're the notary certifying that paper printout is a true and correct copy of the electronic version. Then that printed out electronic document together with the certification is entitled to be recorded in the public records. And in New York, some states left a little bit of discretion to the counties, but in New York, and this was something advocated for by the land title, we really pushed to have the city and the city register and the county clerks are required to accept a papered out document as long as it would otherwise be entitled to be recorded. It's got to meet those, of course, recording requirements, margins, document size, etc. But that's going to be huge. That's going to allow you to effectively do RON in every county in the state. Just for some perspective, when the RON law got passed in Texas in, I believe, 2018, there was about 70 counties that did e-recording out of like 250. And the legislature had to come back and adopt a papering out law so we could then, offer RON in the entire state rather than just those large metro areas. Because it's important for people in small rural areas where notary services aren't exactly easy to find all the time. So that's gonna be very helpful. In New York, just for everybody's benefit, this certification is called a certificate of authenticity. And that is actually located within the statute for anybody who's interested. The citation is Executive Law, Section 135-C, subsection 6. And that makes it much easier for everybody, all the notaries working on this, because you don't have to say, well, what do I have to say in the certification? What does it have to read? It's right there in the statute. You can pull it and it'll make your life much easier to be able to use and rely on that.
Great. And just so for everyone's information, you can charge $2 for preparing that statute of that certificate of authenticity if you so choose.
Yeah. I'll add one other thing. I'm sorry, I meant to say. So this question comes up very frequently. Do I have to be the same notary that performed the RON who is papering out? And if you look at the statute and the regulations, you have to be commissioned as an electronic notary public to perform RON, but any notary public is authorized to paper out that document. So the way the statute reads, it's a notary public. So it doesn't have to be the same notary who performed the RON. That comes up pretty often. I figured I'd throw it out there.
Tim.
I just want to interject here before our time runs out to everyone know, obviously notarial acts go way beyond real estate. They involve many subjects. But, to my knowledge, there's no group out there loudly banging down the doors about how to do bills of exchange, demand letters, and protests, all that stuff, like in the first 100 years of our country. Really great credit goes to Chris and the First American and the New York Land Title Association for being the powerful voice in getting this law in New York and other states. And that's why, it certainly is, naturally their view is land title purposes and how to minimize their risks and all that. But, I think all of us have benefited from that. So I think, I do want to publicly thank Chris and his First American team for their efforts. And I think we all should recognize them for that in New York.
Well, thank you, Tim. It takes a village. It really is a group, and to flesh everything out, it's really, legislatures, we could talk all day, but if people don't conceptualize and see things by getting a demo of a platform or understanding some of the mechanics, they're never going to get things passed. So I think it really was a group team effort. And you're right, it extends far beyond real estate. Even if the Land Title Association was pushing. Thank you.
Thank you all for your efforts. We have a couple more questions, and I know we're a little over time, but Bill, can you tell me what the circumstances would be when a notary could refuse a notarization? There's been some, chatter about, well, I don't want to keep a journal anymore, so I'm just going to only notarize for who I want to and not for anyone else. Can we do that? Can we just choose who we notarize for and who we don't?
Well, if we look at the regulations again, the regulations say that a notary must refuse under certain circumstances, and there is a regulation that says they may refuse under certain circumstances. Okay, so according to the regulation, you must refuse to notarize if any requirement in Part 182 is not met. Okay, this is very broad. So, for example, if a signer doesn't appear before the notary, you must refuse. If you can't satisfactorily identify the notary according to the regulation, you must refuse. Or if the signer will not take an oath or affirmation, if the Notarial Act requires one, you have to refuse. All right. So you also must refuse, according to the regulations, if you as a notary are not satisfied that the official or a presented record evidencing the individual's capacity to act as a representative on the record for notarization, if you're not satisfied with that. So for example, if your signer is an attorney in fact representing someone, and they produce a power of attorney that names them as the attorney in fact, you have to be satisfied that that document says that they have the right to notarize. Okay. So those are when you must refuse. Okay. Now, the regulation goes on to say you may refuse under two circumstances. One, if you're not satisfied that the signer is competent or has the capacity to execute the record. So if the person is not there mentally or is not sufficiently aware of what's going on to as a notary, you may refuse. And secondly, you may refuse if you're not satisfied that the signature is voluntarily made. So if in that notarial act, there are people in the room who are coercing the signer or pressuring the signer to sign, and the signer is waffling, you can put the brakes on the notarization and refuse.
Excellent, thank you. So, Brian, let's talk about RON platforms. So there are lots of RON platforms out there currently, right? And we get questions all the time. Let me start by asking, I've heard, can I still do this by Zoom and do my own, figure out my own identity credentialing or KBE? It would be very difficult to not use a RON platform and do this on your own, correct? Almost impossible is my understanding. Am I correct in saying it?
I would say yes.
Okay.
And, primarily, and, we can lean on Tim and Chris on this too, right? Is, you have stakeholders within the transaction that's going to have minimum requirements. And typically those are going to be, certain certifications, the vendor can meet certain standards, credential analysis, and so on and so forth. So, leveraging Zoom and recording with your phone probably won't meet those requirements.
But in terms of finding a reputable RON platform, because there are so many today, right? And we get this question all the time. What is New York State? Is there a list? There's not a list. They certainly are, regulations or requirements that New York State has for technology. But what should we be asking? How do we vet these platforms to make sure they're compliant for New York, they're reputable, and that they work well for our business model?
Yeah, so that's a great question. So there's a few resources that are available today. For those that are familiar with mortgage and real estate, you have the trade association referred to as MISMO, M-I-S-M-O, MISMO.org. So MISMO is a standards and certification body. They are kind of an offset of MBA, the Mortgage Bankers Association. So currently right now, I think there's 26 or 28 RON vendors that have been certified by MISMO. So MISMO defines minimum standards for RON vendors, ensuring that they're meeting kind of an agreed upon minimum requirements that meet both kind of the state requirements as well as kind of industry best practices. So each vendor goes through an initial assessment and certification process, and then an annual recertification. Actually, we just submitted our paperwork to MISMO just yesterday to renew our certification. Some states, not all, but some states have a list of approved RON providers, right? So where I'm located, Maryland, the Maryland Secretary of State has a list. Not all states and not all SOS offices do that as well. Another location that you can look at is through kind of title underwriters. So many of the title underwriters, or all of the title underwriters, will have a list of kind of approved preferred partners, right? And in that category, it can list dozens of categories, but one of the categories is going to be, an e-close vendor or a RON vendor. And what that indicates is that, these vendors have worked directly with the underwriters. The underwriters have reviewed the RON vendor, reviewed their, information security standards, their technology, their process, all of the requirements to ensure that it will meet what the minimum standards that that underwriter has. So, looking across those three categories can give you a good sense of, a reputable organization as far as the vendors are concerned, because you have these third parties that have evaluated and looked at them on their own. But selecting a vendor, out of 28 or more can be, very, very daunting, right? So, the first question really to ask is, what type of service are you looking for, right? Majority of the RON vendors out there are software providers, right? And so, for a typical notary or a signing organization, they need a software vendor, right? And so you can look at the broad range of vendors out there that provide the RON platform, as a licensed software as a service. Depending upon your organization, you may be looking for notarial services, right? So not only do you need the technology, but you need the, approved RON notaries to be able to conduct the transaction yourself. There's a few vendors out there that not only they provide the software, they also have notaries either on staff or a pool of approved notaries that the transaction can come through, and they will use that platform to conduct those notarial services themselves. Tim.
Just to add to that. So what Brian's saying, so here's an example of going back to your audience here of law firms. Let's take that example, or large companies based in New York. You're going to have offices all over the country, probably, and probably other countries. So now you look at this strategically, you have a few different ways you can go. And I've been involved in such discussions with Fortune 100 companies. You could maybe now use notaries in New York to handle all of the notarial needs for your branch offices in other states.
Mm-hmm.
You don't have to sit there thinking, how am I going to have Ohio notaries, this and that, and let's pick on Ohio. That you could now have New York notaries. You could have no notaries in-house and outsource it to like Notary Cam or someone who's going to handle that part of it, or some combination. So this does mean for a lot of law firms, probably for the first time in their history, there's going to be the subject of notaries at their board meetings with the partners. It was some business strategy part of it. I know that's happened in Fortune 100 companies. This, from the notary perspective out there, I know because Bill Anderson, I think Mark Aronson was in the crowd of the Pennsylvania Association of Notaries, the senior people in the notary world. This is unbelievably exciting situation. I doubt in the paper world the subject of notaries ever got to the agenda of a law firm management committee or something.
Yeah, very similar. Prior to joining Notary Cam, I was at, a mortgage lender, and, our principal, the owner, had relocated to Florida for some reason. Right. And as an owner of the company, had to notarize documents on a regular basis. Right. And so we as an organization had implemented kind of our in-house notary with the technology from a RON vendor in order to be able to still notarize all of those documents. All right. That's a great use case. The last thing that I'll kind of hit on, we were talking about the journal, right? And so as you're looking at features and functionalities of these vendors, right? Bill, you talked about kind of using a repository or a proxy in order to be able to store your journal. So talk to the vendors about, do they store the journal? How do they store the journal? Is it accessible? Is it protected? And the last piece is the video recording, right? So does the vendor store the video for you? Is it part of the fee? Is there additional fees for that? Is it, accessible to you? Do you have to download it and store it yourself? are they using kind of MERS or that type of repository? So, there's several options out there. So it really just kind of depends on what your needs are, to investigate kind of the best vendor that's going to provide the best solution for you.
Great. It's certainly important to ask questions like, if I leave your platform, do I take this with me? Do you keep it? What's the charge? And ultimately, I want to remind everyone that you are responsible for your journal as notaries. So whether you use electronic or paper, it's part of this bond piece. Ultimately, you need to have access to it in case the Secretary of State needs access, and you need to make sure that it's retained for the length of time that New York State requires you to, those full 10 years.
And
So I'm going to wrap up. Oh, I'm so sorry. Go ahead, Brian.
So real quick with that, so like with us, if a notary leaves our platform and they're, retaining their state license, we still retain all of the recordings in the journal and everything like that. We've had situations where a notary will move and move to a different state, and they need to take that with them, or they need to turn it back into the state, depending upon the state in which they're located, right? And so those are all great examples of things to look out for as you're finding these partners.
Absolutely important information to make sure you get. So I'm going to ask this one last question. We'll take 2 quick questions and then we'll wrap up, because I know we've gone over, but this, Tim, is directed toward you, but certainly anyone can jump. And also, New York State is sort of at the tail end of states who approved RUN. So I guess in our regard, great, the kinks have been worked out in other places, but what challenges do you, have other states overcome in this? And what do you think will be challenged, if anything, for New York State to, adopt these regulations and move forward with RUN?
Well, I think that states have, there are only like 6 or so states left that have not enacted remote, and there have been discussions in many of these enactments on the question of interstate recognition of notarial acts across state borders. Fortunately, in at least the states that have enacted the RON, they've worked that out, and they've pretty much kept existing law intact. In the states that remains a big issue, and perhaps even a barrier to enactment that will have to be worked out. It's very important that notarized documents be recognized across state borders to help our economy thrive and to protect everybody's interests.
Does anyone have anything they want to add to that? Okay, take a couple quick questions. Oh, Tim, go ahead.
Well, 2 quick things. I'm a camp of lawyers who see that historically that notarial acts have full faith and credit to include the electronic and all of that, but that has been a subject of some debate and discussion, all that. But up to this point, there have been no rejections of an online notarization at all, and certainly none based on interstate recognition and lack of full faith and credit. It just hasn't even been a challenge. And they've been probably, I don't know, hundreds of thousands or millions of these up to this point since 2011. But the other thing is really the biggest challenge with RON, when we were doing the Virginia law, first discussion, and I think it will always be the case, what we alluded to is the identification of the signer, and the evolving technologies of that. And that is a global issue for sure. We're in it. Some of us, certainly in New York, probably hearing discussions of the idea of a digital central bank currency, all this push for digital everything, which puts more and more pressure on digital identities. And that's going to impact us and the technologies that notaries will be using. We also have, I know Bill Anderson working on mobile driver's licenses, that will great way to achieve L2, for example, under the federal requirements. So I think identity will continue to be probably the greatest challenge in evolving opportunity.
Great. So just a couple of quick questions. again, the exemption, my understanding is there's no exemption to these regulations for, attorneys, that everyone must apply for their e-commission and they're required to keep that journal. Is that correct, Bill? Am I right in saying that?
Yeah, the term used is a notary public. So if you are a notary public and, attorneys in New York, I believe must be commissioned. So that would apply to you. Somebody in the chat talked about commissioners of deeds. They want to know if these rules applied to commissioners. Commissioners of deeds are another office with limited notarial powers. And I don't, to that question, again, the term is notary public. They don't use the term commissioner of deeds. So, Tim and Chris, you may have ideas on this, but I would just say that just applies to notaries.
Okay.
I would tend to agree. Commissioners of deeds are somewhat unique as well, because historically they've had the authority to go outside the state and notarize documents, which wouldn't necessarily jive with the notary needs to be physically in New York when performing the notarization.
Then I know we touched on this briefly before, but go ahead, Tim.
I should have made that point. I want to emphasize that point again about, and for Chris especially, the heartburn of, I'm sure you have a lot of professionals, notaries living in New York that would then go out and, New Haven or Greenwich for the weekend where they live, so forth. And they just do the notarial acts there. That's not just a simple defect that's, can be corrected and all that. That gets back to the basic jurisdiction. You have no jurisdiction operating out of Connecticut. Therefore, the act is invalid. That's it. And so poor Chris is going to have a case probably in the bankruptcy court or so forth. The easiest thing is if somehow a bankruptcy trustee can say that was an invalid act. Because you did it in Connecticut, you didn't have jurisdiction. It's just like a divorce court. This has happened. Issuing a divorce decree, a judge, well, there's no full faith and credit if that judge didn't have the proper jurisdiction over the parties of the case. So, you cannot stress enough to the New York notaries, you must not violate that rule about performing physically while you're in New York.
You're right, Tim. That is something I worry about. I don't know that others do, but I do. And the way I always tell our people is this prevents you being physically in New York or your commissioning state prevents all these thorny jurisdictional issues. We just don't want to have to deal with them.
Wonderful. So most of the rest of the questions pertain to specific platforms and things like that. We will continue to follow up with Division of Licensing and get information out. We will certainly go through and answer any questions directly with you that we weren't able to answer today. I know everyone's time is valuable, and so we're going to wrap up. I'd like to thank the panelists truly for taking time out of your day to do this. I know it's been a little confusing and your expertise was very helpful. The information was valuable. So thank you so much for joining us. And everyone who attended, I commend you for wanting to know more about these new laws so that we all do the right thing, both protect you as a notary and the consumer as well. So thank you all so much on behalf of PNS and the New York Notary Alliance. We will certainly be in touch going forward to do more events like this, but thank you all. I hope you have a great day, and I appreciate you all once again.
Thank you.
Great. Thank you very much, Marcy, for having us.
Everyone.
Appreciate it.
Appreciate it.
Thank you.